Here's a question almost nobody asks about the First Amendment, and it is the one that decides whether any of it is real. Suppose the government violates your rights. Not hypothetically, suppose it actually happens. An official retaliates against you. An agency buries your complaint. A policy silences you. You know your rights were violated. Now answer this. What do you do about it? Every answer to that question runs through a courthouse door, or through the right to demand that the government fix what the government broke. And that right, the right to petition for redress of grievances, is sitting right there in the First Amendment, the fifth of 5 liberties, the last one listed and the least discussed. It is the one that makes the other 4 collectible. So today we are going to do something a little different with the most famous sentence in American law. We are going to read all of it, and we are going to end on the clause that nobody teaches, because it turns out to be the one that determines whether the rest of the amendment is a promise or a receipt. This is Do It for the Case Law. Doctrine Deep Dives, Season 0, the amendments. One at a time, one sharpest gap each. Today, the first. Start with what the text actually grants, because the grammar here is genuinely unusual. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. Count them. Establishment, free exercise, speech, press, assembly, petition. 6 clauses, 5 liberties, 1 sentence. And notice the hedging, or rather the absence of it. Most of the Constitution builds in a dial. The Fourth Amendment bars only unreasonable searches. That word is doing enormous work, and it invites a judgment call in every case. The 8th bars excessive bail and cruel and unusual punishment, which are 3 more words that beg someone to decide what counts. The 5th guarantees due process, which is practically an invitation to litigate what process is due. The first does none of that. It does not say Congress shall make no unreasonable law abridging speech. It says no law. 5 words that read like a door welded shut. That is the promise. Hold on to how absolute it feels, because everything that follows is the distance the doctrine traveled away from it. Now watch what 2 centuries of courts did to that sentence, because not one of those 5 liberties survived contact with litigation in the shape the text describes. And the pattern is the same every time. The absolute becomes a test, and the test is made by judges. Begin with religion, which is not 1 liberty but 2, and they pull against each other. The Establishment Clause says the government may not establish religion. The Free Exercise Clause says it may not prohibit the practice of one. Accommodate religion too much and you are establishing it. Accommodate it too little and you are prohibiting it. The court has spent 70 years looking for a stable line between those 2 failures. For decades, the answer on the establishment side was a 3-part inquiry from a case called Lemon v. Kurtzman, purpose-effect entanglement. Generations of lawyers learned it. And then, in 2022, in Kennedy v. Bremerton School District, the court said it had already stopped using it. Here is the language, and I want you to hear how it is phrased, because the court does not say we are overruling Lemon today. It says, quote, "What the district and the Ninth Circuit overlooked, however, is that the shortcomings associated with this ambitious, abstract, and ahistorical approach to the Establishment Clause became so apparent that this court long ago abandoned Lemon and its endorsement test offshoot." End quote. Long ago abandoned. A test that was in every casebook in the country, and the court's position is that it had quietly stopped applying it sometime earlier, and the lower court simply had not caught up. That is worth sitting with as a fact about how this body of law moves. The free exercise side has its own turn. In 1990, in Employment Division v. Smith, the court held that a law that is neutral and generally applicable does not violate free exercise just because it burdens a religious practice. The language, quote, "Subsequent decisions have consistently held that the right of free exercise does not relieve an individual of the obligation to comply with a valid and neutral law of general applicability on the ground that the law prescribes or prescribes conduct that his religion prescribes or proscribes." End quote. Read that carefully, because it is a rule about what does not count. If a law is aimed at religion, you have a claim. If a law is general and neutral and simply happens to crush your religious practice, the amendment, on its own force, does not save you. The court put it another way in the same opinion. If burdening religion is not the object of the law, but, quote, "merely the incidental effect of a generally applicable and otherwise valid provision, the First Amendment has not been offended." End quote. So on religion, the absolute has become a question of legislative aim and judicial method, not the text. Speech is where most people think the First Amendment lives, and it is where the category machinery is most visible. The move the courts made is this. They split the world of speech into protected and unprotected, and then built tests to police the borders. Take incitement, speech that pushes people toward violence. For much of the 20th century, the government had a fairly free hand, under formulations elastic enough to reach a great deal of unpopular political advocacy. That changed in 1969 in Brandenburg versus Ohio, which involved a Ku Klux Klan leader convicted under an Ohio criminal syndicalism law for a speech at a rally. The court reversed, and it drew the modern line. Quote, "The constitutional guarantees of free speech and free press do not permit a state to forbid or proscribe advocacy of the use of force or of law violation except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action." End quote. Take that apart because every word carries weight. Advocacy of force is protected, unless the government proves two things at once: that the speech was directed to producing imminent lawless action, not eventually, not in principle, imminent, and that it was likely to actually produce it. Intent, imminence, and likelihood. Abstract advocacy stays on the protected side of the line, however repugnant. And to make sure the point could not be missed, the court took the older, more speech-restrictive precedent it was displacing, Whitney versus California, and disposed of it in a sentence. "Its contrary teaching," the court said, quote, "cannot be supported, and that decision is therefore overruled." End quote. Notice what just happened. Whether the government can imprison you for a speech does not turn on the words "no law." It turns on a three-part test a court built in 1969, and a court could rebuild. The press clause tells the same story from a different angle, and here the protection is genuinely old and genuinely strong, but still a test, not a wall. The core is prior restraint, the government stopping publication before it happens. In 1931, in Neer versus Minnesota, a state law let officials shut down a newspaper as a public nuisance. The court struck the scheme down and grounded it in history, calling it, quote, "the chief purpose of the guarantee to prevent previous restraints upon publication," end quote. And it reached back to Blackstone for the definition: "The liberty of the press," quote, "consists in laying no previous restraints upon publications and not in freedom from censure for criminal matter when published," end quote. That last clause is the catch, and most people miss it. Stopping you before you speak is the deepest violation. Punishing you after you speak is a separate and much weaker protection. But you can see the strength and the limit together in the Pentagon Papers case, New York Times versus United States, in 1971, where the government sued to stop two newspapers from publishing a classified history of the Vietnam War. The newspapers won. The line the court used is the one to remember, quote, "Any system of prior restraints of expression comes to this court bearing a heavy presumption against its constitutional validity," end quote. A heavy presumption, which means the government usually loses and also means the door is not welded shut. It is heavy. It still swings. Defamation shows the court's building protection out of nothing at all. False, reputation-damaging statements are, as a category, unprotected. But in 1964, in New York Times versus Sullivan, the court confronted the risk that libel law could become a weapon against critics of government. An Alabama official suing over an advertisement about the treatment of civil rights demonstrators. So the court grafted a constitutional test onto a state law tort. Quote, "The Constitution prohibits a public official from recovering damages for a defamatory falsehood relating to his official conduct unless he proves that the statement was made with actual malice. That is, with knowledge that it was false or with reckless disregard of whether it was false or not." End quote. Sit with that construction. Even in a category the amendment does not protect, even for statements that are false and damaging, the court invented a shield. That actual malice standard appears nowhere in the text. It protects an enormous amount of American journalism. And it is a doctrine the court made and could remake. Assembly is the liberty people assume is obvious and is not. It was not applied against the states until 1937 in De Jong versus Oregon, where a man was convicted for helping conduct a public meeting. The court's language is clean, quote, "The right of peaceable assembly is a right cognate to those of free speech and free press and is equally fundamental," end quote. And it drew the operative conclusion, quote, "Peaceable assembly for lawful discussion cannot be made a crime," end quote. Assembly also carries a companion the text never mentions: association. In 1958, in the case reported as NAACP versus Alabama on the relation of Patterson, Alabama tried to compel the organization to hand over its membership lists. The court understood exactly what that would do. Quote, "It is hardly a novel perception that compelled disclosure of affiliation with groups engaged in advocacy may constitute as effective a restraint on freedom of association as the forms of governmental action the court had previously condemned." End quote. And then the line that matters most, quote, "Inviolability of privacy in group association may in many circumstances be indispensable to preservation of freedom of association, particularly where a group espouses dissident beliefs," end quote. Which brings us finally to the clause we started with, the one that decides whether any of this is collectible. The right to petition the government for a redress of grievances is the oldest of the five. It predates the Constitution by centuries. It runs back through English practice to the idea that a subject may demand that power answer. And in 1972, in California Motor Transport Company versus Trucking Unlimited, the court said the thing that makes it structurally enormous. Quote, "Certainly the right to petition extends to all departments of the government. The right of access to the courts is indeed but one aspect of the right of petition." End quote. Read that again. Your right to walk into a courthouse and sue is a First Amendment right. Access to the courts is petition, which means the amendment does not just protect your ability to complain about government, it protects the machinery you use to make the complaint bite. So here's the question that decides the episode. How much protection does that enforcement right actually get? Less than you would hope, and the reason is subtle. You might assume petition is the strongest of the five, since it is the one that vindicates the others. The court has gone the other way. In 2011, in Borough of Duryea versus Guarnieri, a police chief argued that because he had filed a grievance, a petition, his claim should not face the public concern limit that applies to public employee speech. The Third Circuit had agreed with him. The Supreme Court did not, and it said so bluntly, quote, "Alone among the courts of appeals to have addressed the issue, the Court of Appeals for the Third Circuit has held that the public concern test does not limit petition clause claims by public employees. For the reasons stated below, this conclusion is incorrect." End quote. The court's reasoning collapses the two clauses together, quote, "The considerations that shape the application of the speech clause to public employees apply with equal force to claims by those employees under the petition clause." End quote. And quoting its own earlier decision, it rejected the idea that petitions get special treatment. There is, quote, "no sound basis for granting greater constitutional protection to statements made in a petition than other First Amendment expressions." End quote. The court did leave a door open. It acknowledged, quote, "There may arise cases where the special concerns of the petition clause would provide a sound basis for a distinct analysis, and if that is so, the rules and principles that define the two rights might differ in emphasis and formulation." End quote. Might. In some future case. Not this one. Now, I want to be fair to the court here because there is a real argument on the other side, and there is also a body of scholarship that thinks the court got this badly wrong. Both are worth your time. Start with something striking inside the opinion itself. When the court went looking for what petitioning meant at the founding, it turned to a history of the clause written by Stephen Higginson, published in the Yale Law Journal in 1986, and here is what the court found there, in its own words, verbatim. "At the founding, citizens petitioned on a wide range of subjects, including matters of both private and public concern. Petitions to the colonial legislatures concerned topics as diverse as debt actions, estate distributions, divorce proceedings, and requests for modification of a criminal sentence." Read that list again. Debts, estates, divorces, a request to soften somebody's sentence. Not one of those is a matter of public concern. They are the most private grievances a person can have. The clause historically was the ordinary person's channel for exactly that kind of problem, and the court says so, accurately, in the same opinion in which it holds that a public employee's private grievance gets the lesser protection. The court did not hide the history, it read it, stated it, and ruled the other way. And that is where the scholarship gets pointed. Benjamin Plenner Cover, writing in the UC Davis Law Review in 2017, argues that the dominant reading, the one that treats petitioning as basically a species of speech, fails, in his words, to meaningfully differentiate between the right to petition, the freedom of speech, and due process, and so misses the distinct significance of the petition clause. His claim is that petition is not a junior partner to speech at all. It is a right to a remedy, a right to make the government actually answer. If that is right, then collapsing it into the speech test does not simplify the doctrine. It deletes the thing that made the clause different. Maggie McKinley in the Stanford Law Review in 2016 comes at it from the opposite end and lands in the same place. Her starting point is one most people get wrong, and she says so directly. The Supreme Court has not actually resolved whether lobbying is constitutionally protected, even though courts, Congress, and scholars routinely assume it is. And drawing on the history of petitioning, a system that gave access and formal procedure without regard to how powerful the petitioner was, she argues that the modern lobbying system, which is informal, opaque, and driven by political power, does not fulfill the right to petition. It violates it. Put those two together and you get the sharpest version of this episode's problem. The clause was built for the powerless person with a specific grievance. Today, the powerless person's grievance is measured against a public concern test, and the powerful person's professionally managed access is simply assumed to be protected without the court ever having decided that it is. That is a strange place for the enforcement right to have ended up. So the enforcement right has no independent engine, it borrows the speech standard, and the access to courts that California Motor Transport described has been narrowed in its own right, not by denying the right, but by making it hard to vindicate. In 1977, Bounds v. Smith required prisons to provide meaningful access to courts, which in practice meant law libraries or legal assistance. 19 years later, in Lewis v. Casey, the court explained what Bounds had not done. Quote, "Because Bounds did not create an abstract freestanding right to a law library or legal assistance, an inmate cannot establish relevant actual injury simply by establishing that his prison's law library or legal assistance program is subpar in some theoretical sense." End quote. The requirement of actual injury, the court said, derives from the doctrine of standing, and in 2002, in Christopher v. Harbury, the court set out what a court access claim must actually plead. Quote, "The underlying cause of action, whether anticipated or lost, is an element that must be described in the complaint just as much as allegations must describe the official acts frustrating the litigation. And where the claim looks backward, quote, the complaint must identify a remedy that may be awarded as recompense but not otherwise available in some suit that may yet be brought." End quote. Think about what that requires in practice. To win a claim that you were denied access to the courts, you must plead the case you were prevented from bringing, and you must show that no other lawsuit could give you the remedy. You have to litigate the thing you were blocked from litigating in order to prove you were blocked. One more piece, and I want to be careful about it because the usual summary overstates it. In 2002, in BE&K Construction versus the National Labor Relations Board, the court considered whether the government could penalize a lawsuit that failed but was genuinely brought. It said protective things about genuine petitioning. Quote, "Are prior cases which have protected petitioning whenever it is genuine, not simply when it triumphs." End quote. But the court expressly treated the constitutional question as difficult and resolved the case by reading the statute narrowly instead. So the honest statement is that the court avoided deciding the constitutional question, not that it settled it in petitioner's favor. That distinction matters, and this show would rather be accurate than tidy. So where does that leave you actually? Two gaps, and they stack. The first is the one you can see across all 5 liberties. What protects you is not the word no, it is a stack of judge-made tests, imminence from Brandenburg, the heavy presumption from Neer and the Pentagon Papers, actual malice from Sullivan, neutrality and general applicability from Smith, historical practice replacing Lemon and Kennedy. Every one of those was built by a court, at a moment, out of a particular set of worries. Brandenburg overruled Whitney. Sullivan rewrote centuries of libel law in one opinion. Kennedy announced that a test everyone was still teaching had already been abandoned. What one court builds, another narrows. So the honest way to state your position is this. The First Amendment you have is not the 45 words on the page, it is the current doctrine, the tests this court is willing to enforce right now. The second gap is the one we came for, and it is sharper. The clause that exists so that you can make the government answer the right to petition, and with it your access to the courts, has no independent constitutional engine. When the court was asked whether petition deserves stronger protection than speech, it said no, and applied the speech framework instead. When it was asked what access to the courts guarantees, it required actual injury and demanded you plead the very lawsuit you were prevented from filing. That is not nothing. Access to courts is a real right with real force, but it is thinner than the architecture suggests, and it is thinnest exactly where you would want it thickest, for the people with the least ability to litigate their way to litigation. Which is the honest answer to the question we opened with. What do you do when the government violates your rights? You use the 5th liberty. And the 5th liberty is protected about as well as the first 4, no better, and getting a court to hear you about it is a procedural climb. That is the primer. A full First Amendment season on this show takes each of these apart properly, the establishment and free exercise clauses and the collision between them, the full architecture of speech categories, the press, and the shield it does and does not have, assembly and association, and a season of its own on petition and the right of access to the courts, which is where constitutional theory meets whether anyone can actually use it. One doctrinal question per episode, each anchored in cases we verify, not remember. A quick word on how this show works, and then I will let you go. Everything you just heard is legal education, not legal advice. We are teaching how the doctrine moves, not telling you what to do in your situation. And everything is built on real, named, verified cases. Every holding quoted today was pulled from the court's own opinion before a word was written, and you will find every citation in the show notes. That is the whole ethos, and it is the name of the show. Do it for the case law. I will see you at the next amendment.